its previous actions will inform decisions that it will make today to ensure some sustenance or let people accept that there's some level of consistency in what they do. But you realize that at least over the last few days, there is that perception that some of the rulings may not necessarily be consistent with other previous rulings. Now, for the average person who does not understand how the Supreme Court in its own wisdom operates, how should such people handle such issues or react when they appear subsequently as the case has started?
Yeah, like I said earlier on, that the people should be worried. So people who are a bit enlightened about how these processes work, like you stated clearly, we call it precedent. You know, the courts are supposed to follow precedents. You know, we cannot just predict that the court will go in a particular way all the time. Well, because decisions have been made in similar cases, similar rulings have been made, and those are what we call authorities. And so we expect the court to follow those processes. So if the court, the Supreme Court, we normally say that they are the master of their own rules. And the Supreme Court actually, you know, all the lower courts are supposed to abide by the decision of the Supreme Court, whatever standard the Supreme Court lays in cases, in their rulings and judgments. All the courts that are lower are supposed to follow the same precedents. And that's why lawyers, whenever we are making our arguments or submissions in court, we cite authorities, decisions that were made by higher courts to the lower courts to follow. And the Supreme Court is also generally expected to follow such precedents that the court itself has established. But the Supreme Court can actually also depart from its own previous decisions, which is what we have seen many times. It's not very common because we say the law is in the bosom of the judges. They have made those decisions. Those decisions have become laws. So, and to guide lawyers and for consistency, as you have said, they have to follow those decisions. So if I'm going to court and I'm making submission to the court, to the Supreme Court, I should be assured that there were decisions that were made in similar matters and this is how they have ruled. And so I should have that confidence that they are going to follow that. Unless there are exceptional circumstances for which they will not follow that, for which they will want to depart. But in recent times, we have seen them consistently depart from their own decisions.
That is where the controversy is. And for the purpose of public education, I believe that anybody goes to an institution for redress based on past cases and how they were handled.
Yes.
That is when a lawyer can say that you have a case because we have seen related cases and how they were handled. Yes. And therefore, the lawyer will lead you to a court, in this case, any court, yes, to file a petition and subsequently expect that it will be judiciously addressed. Yes. But where we have these controversies, conflict of decisions, I'm using it advisedly because if there's supposed to be consistency and there is a public perception that that level of consistency, that should guide that, well, this is the trend, but it is otherwise. And therefore, the question is, how then do you conclude that a certain decision has fairly handled the concerns raised?
Yeah, yes. The question is very legitimate, and like I said, you see, but at least one thing Ghanaians should maybe be happy about is that these things do not happen in other cases as much as it's happening in a high-profile political matters like this. So the problem is, I have always said that the courts behave differently in political matters. That is my problem, because all other matters, the courts are not doing generally badly. They follow the precedents. In a few cases where they have to depart, they depart. But in the political matters, and of course, because we are divided, between MDC and NPP, and so people have become so partisan, and we don't want the court to become partisan as well. But people are reading partisanship into the decisions of the courts, and people are doing that, and then others seek to tell people that don't read partisanship into the decisions of the court, don't think the courts are partisan. But you see, you can't just tell people not to do that. We have to see it from the actions of the court, from the conduct of the court, from the decisions that are coming from the court. That is what is going to determine what people will think. And so I think there's a cause for worry. There's a cause for worry, and especially in these political matters, high-profile political matters. especially when it comes to issues between MPP and NDC and all of that. And I just hope that the court will live beyond reproach. They would act in a way that all of us should have confidence in them. In fact, I'm a lawyer. I'm not supposed to say that I don't have confidence in the courts. But so far in these political matters, I don't think I'm very happy with the kind of decisions that are coming from the court.
So lawyer Eric Alifo is a private legal practitioner. He's here with me in the studio. The conversation is on the Supreme Court case, the election petition case challenging the presidential results. And at this particular moment, we have tried to look at previous incidents, the arguments in court, decisions by the court, the relevance of some of the questions raised. Now, the EC and the NPP have been consistently saying that, look, the truth is that the NDC doesn't have a case. And so the Supreme Court is, the time of the Supreme Court is just being wasted. And therefore, all the complaints by the NDC lawyers are just gimmicks. And there's nothing. And therefore, the public must be informed. I'll be taking your response on some of these arguments that come up often. But let's go to the Supreme Court. Wisdom, Hede Jome is standing by. Wisdom, good morning. Unfortunately, Wisdom is off the line, but I'll try the last time. If we fail to get him, then perhaps we may have to give up. But you can also join this conversation by sending us your concern or your opinion or advice or recommendation or anything of interest to this conversation. The number is 020-866-7000, 020-866-7000. Send us text messages via WhatsApp. We'll read them as they come in. But lawyer, I was making reference to how some of these things are going, and particularly the conversation on social media, the conversation on news portals have always been around issues raised by the NDC and how they were handled. Yeah. So Supreme Court has thrown away this, Supreme Court has done this, Chajukata is complaining this way, NDC lawyers are saying so. But the other side of the argument comes from the Electoral Commission, which is virtually represented by the position of the MPP, because the two of them are on the same page. Yeah. And so if EC is not hurriedly going to the media to express their side or their own assessment of rulings or conversations in court, the NPP does so. And we assume that since all of them are on the same page, whatever NPP lawyers are saying may be reflective of the reasoning of the NPP lawyers. Yeah. But they have a simple position. Mm-hmm. You don't have a case. Yeah. And so don't waste our time. Mm-hmm. You can complain, but the fact is you are just making mistakes. I'm told Wisdom is on the line. I don't want to lose him this time. Wisdom, good morning, and thanks again in this attempt to get you.
Good morning, Eric. I'm told you've been struggling to connect to me.
Thank you. Yes, Wisdom, quickly before we lose you again, tell us what's the atmosphere around court and who has come in so far?
So far, the running mate of the NDC in the 2020 elections, Professor Jinano Pokwajiman, has arrived. So as the national organizer of the NDC, Joshua Akamba, understand General Secretary is around. He's yet to make entry into the courtroom. The Information Minister designate has also come from the second respondent side. We've also seen some military personnel around as usual, who are wrecking the environment ahead of the arrival of the EC chairperson and some other officials from the Electoral Commission. And so the lawyers as well from the three sides have all also entered the court premises, and we're expecting some other dignitaries to come in as well. And so basically that's what's happening right now.
Picking, we know that the main case will begin today, and we have already had some hints that Johnson Asedun Ketia will be in the witness box, will be like today.
And so what I'm told this morning is that, like you rightly mentioned, the main trial is starting today with the petitioner bringing in his two witnesses. That's the General Secretary of the NDC, Johnson Asedun Ketia, and Dr. Pester White. But it is still not clear as to who will mount the docket yet, who mounts the docket first, as well as going to be the General Secretary or the Dr. Pester White. But we are taking lead that it's possible that Johnson Asedun Ketia will be the one to mount the docket first, and that there's a likelihood that the former president himself, John Mahama, will be in court today to witness proceedings, especially when his witnesses will be testifying before the court. We're so picking leads that he may come to court this morning, and then the processes will continue. And so we expect that at 10 a.m., when the court sits, all of these individuals will be present to help hear the case as been expected, because the trial period and then the case management period have all elapsed, and then today is the cusp of the matter as we're beginning the hearing proper, if you want to put it that way. So it's today that we expect that the witnesses will manage the docket and then start the court case proper.
Okay, Wisdom, so before you go, we've always been asking, we had an idea about how the security operatives want to position themselves around the premises. Yesterday, you said they are taking the backside of the Supreme Court to avoid unnecessary attention. Is it the same today? Have you seen anything unusual?
No, it's still the same thing today. Today, as always been the case, they positioning the water cannon at the entrance of the court premises. And then if you enter the yard, you see the military men standing at vantage points within the premises. But this time, you don't see them wielding guns. They are just, positioning themselves around. And then the police also have taken the backstage of the court premises. But then if you enter the premises, you see one of them, 1, 2, 3 of them positioned at vantage points. And so once you enter, you won't lose sight of them. The positions they have taken, you definitely see them.
Thank you very much. Wisdom Hedejoma is one of our reporters who has been going to the Supreme Court to give us some details about what has been happening. We're talking about the concerns raised by the lawyers on the other side, because the NDC has gone to court. So most of the conversation will be about what they have to present to the public, the evidence they have to justify the argument that Nana Akufo-Addo did not win more than 50% of the votes. The concerns raised about pink sheets. I've seen the witness statement by Johnson Asedu Nketia, and attached to that witness statement are some of the pink sheets which have figures NDC is disputing. But before Wisdom joined us, I was making reference to MPP's position and why Ghanaians must equally show interest in what they claim the NDC intends to do.
Yeah, well, the MPP position, MPP is the one NDC is battling right now in court, yes. And so, of course, they cannot come out and say NDC has a case, because then it would mean that they are defeated already. And so they have to fight. And so I don't think that people should necessarily take their comments to be what is happening in court, actually. So, yeah, and again, the challenge is against the Electoral Commission, which is the first respondent. And then the beneficiary of the wrong declaration the first respondent has made is the second respondent, is the president. And that is why they both are on the same side. So whatever the victory NDC is going to get from the first respondent, which is Electoral Commission, is going to affect the second respondent, which is the president. That's the president that was declared as a winner from the election. So they have one voice. And that is why whatever NDC is doing together, in fact, some people may even think that perhaps they put their heads together to file their defense, similar response to the petition. So actually, but again, before even the petitioner would go to court, there was a debate. I know there was a debate among NDC lawyers and supporters at the grassroots level and party executives as to whether they would have justice in the courts. And so, and because of the debates, and then I believe there was a view of some people in the debate that, well, just go to court and put up your case. Let the whole world see the case. The whole world listen to you, and then they will know whether you have a case or not. Because the reason why some people were apprehensive of going to court was because they were not too sure whether the court will rule in favor of us. And they think that from past rulings, past judgments involving NDC,
But some will say those may still remain perceptions, because we have the privilege of watching proceedings live.
Yeah.
And the interrogations that will go along the line, the arguments in court, the objections that will be raised, the rulings by the Supreme Court, either to uphold or overrule or allow the lawyers to go ahead, either through cross-examination or you call it examination in chief. Is that how you call it? If I'm cross-examining my own witness, how do you
are
call
not cross-examining him. You are leading him to give evidence. That's
you are leading him to
chief.
give in evidence. Sorry, but we are all learning.
Yes.
Now, many people are saying, why don't you allow the judges to do their own thing and allow the rest to be their own integrity, conscience, what they anticipate to be the public perception about what they are doing, and allow faith to help us to appreciate the final judgment. But it looks like there's a group of people in Ghana who have already formed that opinion that there's every reason for us to be suspicious, and therefore every act or every decision that is taken as we move along.
Party, if you have a case in court, or you are even a lawyer in court, and they make a ruling against you, you complain, especially if you have so much confidence in your case, you think you have a solid case, and they rule against you, you complain. So there's nothing wrong with that at all. But what I was driving at earlier was that because of the perception, you see, perceptions can be real. Perceptions, that's why the word perception is there. They can point to facts and reality. So the fact that there was that perception and the fact that there was this debate as to whether NDC will have justice in court, that was the reason why it was very important. And then the people, I believe, the school of thought that said, well, just go to court and the whole world will see what you are presenting in court. And that's why it's important that NDC has to come out always to speak to the public. And it happens everywhere. In fact, in developed jurisdictions, if you go to court, they have to come out and tell the public, this is what we presented in court today. This is how the court ruled. We disagree with it or we agree with it. There's nothing wrong with that. Now, from that, I believe that people who are discerning enough and are following proceedings religiously will be able to tell whether
so they'll be able to make their own deductions.
Yes.
I'll be sharing with you the reliefs being sought by the petitioner, but I called for some text messages. You can send us by WhatsApp 020-866-7000, 020-866-7000. This one says, hi, good morning. Keep up the good work. I think Delano Alifo is actually Eric Delano Alifo. He's a private legal practitioner. We think that he's just being frank. All our eyes are on the Supreme Court. This one is coming from Felix. This text message says, hi, XYZ. We are setting it all. What we are seeing is clear that the court is not independent. Former President just continues demonstrating the corruption in government. Well, I'm sure you are trying to suggest that the demonstration must continue. It's just unfortunate that even at this early stage, people are harboring their own suspicions. But in my personal opinion, these suspicions perhaps are good, they are healthy. Then it puts the Supreme Court judges on their toes. I don't know if this comment is appropriate.
Yeah, well, you know, like I said, you cannot force people not to have suspicions, because it's coming out of what we are seeing, the conduct of the court. And so you can't say that because I have a wrong suspicion, I have done anything wrong, or I should be castigated. Point is that I can suspect anything I want to suspect. But people who are acting have to act in a way to disprove
you wrong.
Yes. So
okay.
Yes.
All right. This text message says, "Good morning. I want President Mahama to clarify how he's going to legalize Okada if he should win." This is an old text message. This one says, "If it is possible that the international court can be consulted, then the NDC should take action by transferring the case to the international court." Evelyn from Dodowa sent this. I know it's inappropriate at this stage. It's too early. And I don't even know whether the international court would want to adjudicate in the case involving elections in a different country.
No, they don't have the jurisdiction to do that. We can, I think the International Criminal Court, they have jurisdiction if there are issues of genocide. And, 8 people were killed during these elections.
Sure.
And then the pressure is on the government to do something about it. They are not doing anything about it. But I believe it's early days yet. I think that we have to put a lot of pressure on the government of the day to do something about that. If a case like that, perhaps we may explore whether it could be taken out of Ghana in case our government is not doing anything about it. Because but the election petition, adjudication of elections, no. The only way I believe the international community and not a court, but we know we have the United Nations, we have the AU, ECOWAS, and all of that. The only way they may get into situations like this is if they see that there's no peace in the country. There may be conflict, there may be mayhem and all of. They are concerned about that because they always want to ensure that there's peace everywhere. And so, but if all of us are very comfortable with what is going on and everybody folds their arms, I don't think they would want to meddle.
Well, let me take advantage to acknowledge our sponsors, X Natural Mineral Water. I have the bottles with me. This one in particular looks quite very well packaged. It can comfortably fit into the bag of your child if she or he is going to school, especially the toddlers. Very, very portable. I'm sure if you are interested, you can follow the crawler on our screens from time to time, and you get to where you can get them in bulk purchases. This is another brand of X Natural Mineral Water. Very rich, naturally packaged, and I'm sure if you get it for any function, birthdays, you can use it for corporate events, you can use it for your offices. I believe that I can only recommend that when you have a fresh baby, imagine at the adoring, you have these packaged for them to not be bad. So just keep watching our dial, keep watching our frequency, TVXYZ on digital TV channel, on satellite TV platforms, on other digital platforms. I'm told Ago TV, for example. Sorry, is it Go TV? Sorry for that. Go TV. You can get us on one of their channels. So just keep following us on TVXYZ. Wazer TV is also available on Facebook. And very shortly, we're crossing over to the Supreme Court to bring you live proceedings. I'm here with lawyer Eric Delano Alifo. He's a private legal practitioner, and we are having a conversation on issues that have happened so far. Now, let me walk us through the reliefs being sought by the NDC. Among them, they are saying that the EC Chair Jean Mensah's declaration on December 9, 2020 was in breach of Article 63.3 of the 1992 Constitution, that based on data contained in the declaration, no candidate satisfied the requirement of the stated article to be declared as president-elect, that the declaration is unconstitutional, null and void, and of no effect whatsoever. An order annulling the declaration of the president-elect instrument 2020 CI 135 dated 9th December 2020 issued under the hand of the EC chair, an order that an injunction restraining Nana Akufo-Addo from holding himself as president, and an order of mandatory injunction directing the EC to conduct a rerun of the election, which he, Mahama, and Nana Akufo-Addo are candidates. Now, these are some of the reliefs being sought. One, I've seen arguments already during the pre-trial as to whether EC's declaration on December 9 and the corrections that were made were privy to the agents of the political parties. Yeah. And the fact that if they were actually contacted and what role they made. Yeah. I've seen arguments in the form of an application, which I don't know has been accepted, for copies of the pink sheets that EC used. Mm-hmm. I've seen a statement issued by the NDC cautioning its agents across the country that woe betide them if they are influenced to sign any other pink sheet. The suspicion arising from that statement is that perhaps EC doesn't have, or EC may want to present other what the political parties already have, and therefore the ones that they are coming out with may be the ones they want people to use fictitious means to sign and present them in court and use them against the NDC. Whichever the way they are, these are all suspicions. Mm-hmm. Now, if you look at the reliefs being sought and these things that are unfolding, many people will say, based on the laws the Supreme Court, NPP lawyers, Chachuchikata and co are quoting, all of them are quoting from the same laws we have. Yeah. And all of them are saying what we are quoting are still statements we can use to back our argument, and for which reason we are good to go with what we are saying. Yeah. For us as individuals, we are confused and we don't know who is really telling the truth and who is misleading us, or who has already made up his mind and is only wasting our time.
Yeah, so far, what has happened in court regarding the applications that have been made, I think that they are more about legal issues than just the facts of what happened on December 7th in December 9th. And then 10th, that's the subsequent corrections that were made to the declaration of 9th December. So they are happening in court, and the Supreme Court is ruling over those issues. So I don't think that ordinary people and or laymen, that is scheduled to happen today when our Honorable General Secretary speaks. And again, I explained already that I don't know how it's going to go, but in the past, the practice was to tell the court your evidence in chief, tell the court all your story, the reason why you have come to court. But right now, those things have already been filed. And so all that his counsel is going to do is to ask him whether he has indeed filed his witness statement. And if he says yes, they'll ask him if he stands by it. And then they'll begin to cross-examine him. So maybe through the cross-examination, people will begin to see the facts, because I know he's very good at putting his case properly before the court. And so people will begin to get a story. Because basically what the petitioner is saying is that the declaration that was made on the 9th of December was unconstitutional, because the requirement of the Constitution, Article 63 or so, says that a candidate that will be pronounced as president-elect, if NDC is saying, if the petitioner is saying that nobody, and in fact, and the declaration, let's remember that the declaration was made once, and it was on the 9th. So the 9th declaration has to stand out. You have to pick it up and then let everybody see that this is the declaration that was made on the 9th. These are the numbers, these are the figures that were given. And this was the president that was mentioned as being the president-elect, and this is what the president obtained. So if that, look, it's just mathematics. If you can calculate all those figures and ascertain that the president has got 50% plus, then of course the president has won. But if the president doesn't get that, then the declaration on the 9th is unconstitutional.
I'll come back to you. Lawyer Eric Delano Alifo is Eric Delano Alifo.
That's correct.
It's a private legal practitioner. He's in the studio with me this morning. We went to the Supreme Court. We are told it's already in court. NDC National Chairman Samuel Ofosu-Ampofo, I'm told, is here to appear. National Organizer Joshua Kamba is there. I'm told Johnson Asedun Ketia, who we expect to be in the witness box later this morning, is also there. The MPP lawyers are there. Frank Davis and his team are there. We are also told that the EC lawyers are also present. We are actually waiting for the panel of judges to resume their seats, and then we go straight to the Supreme Court to bring you live proceedings. Now, some more text messages. This one is from somebody who didn't add it. Hi, Mr. Eric, can the NDC move the case to ICJ? I think that's been answered. It's inappropriate at this time. I don't think it's acceptable. Now, Musa Abatwa in Kumasi. Musa, good morning. I follow you on other platforms. He says, good morning, Eric. Clearly, there are a lot of political sentiments in our legal system. Hence, fairness and justice is becoming an expensive commodity, especially the apex court. You claimed some questions irrelevant in the case before but in another breath, you said you can be asked during the cross-examination. Was CI-99 bars interrogatories, or I think I want to edit some of the text. He said, does CI-99 bar interrogatories being served to the respondents? No. Was Akufo-Addo allowed to serve respondents in respect to the same case in 2012? Yes. Why is it being disallowed now? The decision is making us lose interest in seeking justice at the apex. Judulali Danku, Kofi Judulali. Jidulali.
Yes.
I also eat akplan and okra soup, but unfortunately, I'm struggling for Jidulali. That is
the victor.
The victor, or yes, the victor is around.
Yes, kind of.
Something like that. Jidulali, good morning. Good morning, XYZ. Please, can you read for me the CI that they are talking about? In this case, Samuel Kofi Judulali Danku is asking. I will ask the lawyer in subsequent conversations to find out if he can provide. He says the CI that they are referring to in some of their rulings. I don't know which of the CIs, but if you can send it back again and be specific, I believe that they can help us to answer that one. This one is from Frank, from Ken Hassan in Zabzugu. Eric, I think the case at the Supreme Court is already predetermined by the judges. What is good for the goose is good for the gander. Yes, you can be suspicious, but I just want to say let's be measured in running with our conclusions and wait till the proceedings are over. I believe that as the as the lawyers begin to interrogate the witnesses and how the Supreme Court will be seen to be adjudicating in the objections raised and otherwise, you can then begin to form your opinion. But for now, I will advise that let's keep watching, because we have the privilege of watching proceedings live. Our democracy is suffering, and it seems those whose hands have been entrusted in our justice system I don't know where you're calling from, sending this text message from. This one says, good morning, Mr. and I'm Francis. I want to ask the reason why the Supreme Court is not accepting the question to be asked by Chachu. They should allow the EC to answer the questions, then we can see who is winning the election. I think we are told that the EC obviously will be cross-examined.
Yes, definitely.
Right.
Yes. They
so
have
if they are going to be cross-examined, the interrogatories that were not accepted may come up eventually, isn't it?
Yes, but
so why should I be worried if I'm Chachu Chikata?
Yes, but before then, you see, I heard you advising listeners and our audience that they should just take their time and watch. They have watched enough already to make conclusions. I would disagree with you that you are telling them that, well, they should monitor how the case is going to go. The people should not jump to conclusions because somebody said that it appeared to him that the case was predetermined and all of that. Look, they have watched enough to make conclusions. I wouldn't tell anybody not to make conclusions. People can, like I said earlier, people can suspect whatever they want to suspect based on what they have seen so far. So for me, if what you have seen so far, I am worried. So people are worried. I will not tell them not to be worried. They have to, and the court, if they are listening and people are listening, they should see that people are getting worried. And if people are getting worried, then they have to sit up. But if you keep telling us, even at this point, that, oh, don't worry. People are worried. We have seen.
I agree with you perfectly.
Yes.
But I also have a certain responsibility. Mine is to ensure that we all have the same orientation as we go into monitoring proceedings in court. And so while I agree that anybody can be worried because of what has happened, I am personally worried about a few things I've observed. That's why some of them have come in the way of questions to lawyers who have appeared on this program. I don't have anything about it. Yeah. I'm also equally worried that, as we saw in the US, there was a certain president called Donald Trump. When he lost the elections, he said he had won. Donald Trump started calling for things that must be done. Yes. He went to court, but the institutions stood the test of time. Even at the time he was being impeached, you could clearly see that this was an America which had so much confidence in institutions, and the institutions were demonstrating enough for the public and the world at large to realize that even if America's democracy has been dented in terms of the image and all the things that happened, including the attack on Capitol Hill, you realize that the institutions have demonstrated to the world that, look, America's democracy is strong, and those institutions can still assure the people that trust us. And Donald Trump could have done whatever he wanted to do, but he will suffer the consequences. And we also saw how he exited disgracefully.
Yeah.
We are in another part of the world, and similar things are happening. And people have every reason to raise the suspicions you have spoken about. I am saying that let them continue to raise the suspicions, but drawing conclusions even ahead of the main case and the way it will end, they should relax and let's observe. Well, when we are getting closer to the end, they will join others of the same mindset to conclude.
Okay, well,
so that is where I have a little departure from.
You said you have a responsibility to do that and to advise your audience. I don't think I have any such responsibility. What I can tell people is to make their own judgment, and if they want to make conclusions based on what they are seeing so far, they should feel free and express it. I'm not going to tell anybody that, look, just keep waiting and keep seeing things going wrong and still keep waiting, keep giving benefit of that until finally they slap you in the face. I'm not calling for anything, actually. I'm only saying that people should think whatever they want to think based on what they have seen so far. And I am worried with what I've seen so far. And if others are worried, they should be worried. They have the right to be worried or not to be worried, and they have the right to express same. So my point is that people have seen enough. There are applications. In fact, the applications they leave for interrogatories, for instance, that was dismissed. You see, it was nobody can understand why something like that would be dismissed. These are simple questions they want them to ask. In fact, even if and then for the fact only because we want to expedite, the case has to move quickly. And so you deny fair hearing to a party that is asking, look, some of these things, in fact, so even if a court, I'm not saying this court is necessarily biased, that is for all of us to look at and judge if that's the conclusion we are all coming to. But even if a court wants to be biased, in reality, there are certain applications you can grant which will just give resemblance of being objective. And this should be one of them, because I don't really see why a court will reject these interrogatories. And they rejected it. And if people are saying that they have rejected this, there was a review, you rejected a review application, they wanted a supplementary affidavit to support the application for the review, is rejected, and so people are making conclusion that, well, with all this, I think that this case is not going to go well. I'm not going to tell the person that, no, don't worry, you just
So at this stage, and as you spoke, what came to mind was what became a mantra after former U.S. President Barack Obama's visit to Ghana, when he said institutions must be strong, let's nurture them, let's grow them, and so on. We know that what people are doing at the moment is like a whip system.
Yeah.
They are sending signals to all parties involved that we are clearly observing. We are equally monitoring what is happening, irrespective of the fact that we may not be lawyers. We can make our own deductions. Now, I am asking if the international community, for example, should be interested in what is happening in court and should show their presence in the courtrooms to make everybody aware that, look, they also have an investment in Ghana to protect. And therefore, while they are going to help Ghana grow as a democracy, they want to make sure that they have first-hand information on whatever we are doing as a people.
Yes, obviously the international community will be interested in the ultimate decision and what will happen subsequently. They will be. I'm not too sure if their presence in court is going to change anything very much. So that is not what I would call for.
The presence in court, you follow the case religiously.
Well, yeah, well,
they may be doing it. That's what you are suggesting.
Because yes, there are press conferences, there are tidbits, news briefs about what is going on, and then the final judgment would come and all of that. They can, and I believe they probably even have the processes that have been filed, the petitions and all of that. Those that are interested may even have copies of all of those already. So yeah, they would be interested in the ultimate decision. They cannot tell the court to behave in a particular way.
No, that one they cannot.
Yes, they cannot. So, and the, the school of thought that said we had to, petitioner had to go to court necessarily, they had this belief that because the television cameras are going to be there, the whole world is going to watch and all of that, and so that would make it difficult for the court to be biased. I don't know if we are realizing that in a way. I don't know.
I'll come to you. I'm told that the court is about starting proceedings, and so I want to run through a few more text messages, and then we take some concluding remarks before we join them. This one says, good morning, Eric. NDC is becoming too slow in doing things. In fact, our leaders are killing us slowly, and they should be careful. This is Alaji Sani from English Amafro. This one says, Eric, what should an individual do if one decides to sponsor in their own small way? Nyako inside Abuase in Wasa East. I mean sponsoring of XYZ. Oh, sorry. I'll call you after the show and I will give you more information about where we need. And don't forget, we have X Natural Mineral Water. I've been showing you the bottles, very, very compact, good for all kinds of events, corporate events. You can order them for your offices. Then we'll be supplying you daily. We can give you the contacts. We are proud that they are there. If you want to sponsor this program, just call us and I will link you to those in charge, and they will give you a very comfortable package to give us the support to run our shows, especially to help give you the real side of things that are happening in this country. Because there are times when you hear people complaining that we have not had enough, or what perhaps is happening, we don't think those who must be telling us are being as frank and sincere in bringing out the issues. We can tell you that we will do so. The court, I'm told, is just starting, and therefore one more text message before I wrap up. This one is saying, is from Walanyo Prosper in Bogoso. Good morning, sir. Thanks very much for your teachings this morning. I hope the NDC will surely come out victorious by the end of the day. So, I'm told the court is sitting.
Okay.
I just want us to relax. Eric Delanyo Alifo is a private legal practitioner. He's going to be with us for some few minutes. let's witness proceedings. If it is not going to drag, then Eric will be with us. But if it's going to drag, let's say beyond the next 2 hours, we'll leave it here and stay glued to TVXYZ and Wizard TV on Facebook.
Akoto Ampao appears for the second respondent. My lords, with me are my colleagues Frank Davis, Kweku Esirfi, and Yao Pong.
My lords, our first witness is ready. We have indicated that depending on the response to the request to admit facts, there may be a supplementary statement from him. I don't know whether your lordships want us to make a formal application for that supplementary statement, or whether based on our indication in the statement, in the witness statement that is filed, once we confirm the status of the request to admit facts, that will be taken as granted, because, I mean, I just want to be clear so we are guided appropriately. I'm sorry?
We want to take the witness first.
Very well.
Bible. I, Johnson Asiedu Nkatia,
Do in the name of Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give
that the evidence I shall give
in this case
in this
and
truth
nothing but the truth.
and nothing but the
So help me
truth.
God.
So help me God.
I lost SOD in English.
My lords, I believe the procedure, since it's not expressly provided in CI 99, I believe the procedure is as provided in CI 47 in respect of witness statements being. I just needed to be clear. Maybe so we're getting a copy of the file copy of the witness statement. Yes, so that we can, what we have filed. I'm sorry.
And then we adapt it as his evidence in chief, and then cross-examination will follow.
Yes.
Just so that we are not caught by time, we have objections to certain parts of the witness statement, and we would apply to the court to have those parts struck out as not relevant nor based on the pleadings of the petitioner, or otherwise scandalous and prejudices unfairly.
Mr. Kotuampa, the witness is here to identify the witness statement. So just wait.
No, I'm just serving the court with notice, because it is sometimes assumed that if you keep quiet and you tender it in, then you are caught.
Mr. Kotuampa, we don't tender if it becomes evidence. Then if you have any objection, you can raise it. Yes. As it is now, it is not evidence before us.
Please give your full name to the court.
I'm Johnson Asiedu Nketia.
And you have filed a witness statement on behalf of the petitioner.
Yes, my lord.
Can you identify what the Deputy Registrar has made available to you and confirm that it is the witness statement that you have filed?
Yes, my lord. This is a witness statement that I have filed.
My lord, we wish to tender that witness statement, or it's taken, it's adopted by the, yeah, very well, very well. That's the procedure.
Yes, my lords, as I've said, we are objecting to certain paragraphs or parts of some of the paragraphs in the witness statement of Mr. Johnson Asiedu Nketia. On the ground one, that they are not based on the pleadings. 2, they are not, they tend to unduly prejudice some of the parties to this suit and are scandalous, and accordingly we would pray that those paragraphs or parts of those paragraphs be struck out as such. Yes.
The grounds of objection. The first one was that it was not based on the pleadings.
Yes.
And the second one, unduly prejudicial and scandalous.
Yes.
Yes. What is the third one? The third ground. Is it scandalous?
Yes.
Oh, okay.
My lords, I believe that it's well established that a party's evidence.
But could you identify the paragraphs first?
Very well, very well. My lords, we are referring to paragraphs 21, No, I have it. Yes, Valerie.
You have set out 3 grounds. Which of those 3 grounds is applicable to paragraph 21? What I'm asking you to do is tell us your ground of objection within the 3 before you start your argument, so we can follow you.
Hold on. My lady, paragraph My lady, paragraph 21 is not pleaded. There's nothing in the pleadings to that effect. Yes. The pleadings, this evidence that they're seeking to lead is not borne out by the pleadings, my lady.
It's not based on.
It's not based on.
Okay.
My lords, We also object to...
Do you mean the reference to the website in that paragraph?
It says moving and changing and subsequently deleted. These are very material facts. If they sought to rely upon it, they should have pleaded it.
Yes.
My lords, we also wish to take objection to paragraphs 6 and 7 as completely out of place. Out of place in the evidence in chief.
What does that mean? What does being out of place?
It's not admissible, my lord, because yes, because it's not admissible because it was not part of their pleadings. Their lawyer may raise that matter before the court in address, but this cannot be part of their evidence.
Paragraph 7 or
6 and 7.
My lords, we also take objection to that portion of paragraph 25, which starts on page 6 of their witness statement. Thus, the first respondent, in respect of the declaration of presidential election, betrayed the determination on the part of Mrs. Jean Adukwe Mensah as returning officer for the presidential election, and certain officials of first respondent to have second respondent installed as president of Ghana by hook or crook. My lords, we think that this is highly prejudicial and scandalous. There's no pleading that can support this type of scandalous and prejudicial piece of evidence, and we pray that it is struck out on those grounds. My lord,
the sentence starting from page 5, in fact,
yes.
So it starts from page 5.
Yes,
and
you are right.
Ends at
page 2. Yes, it starts from page 5. Well, relax. They're writing. My lords, our next objection, the chairperson of first respondent, Mrs. Jane Adukwe Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018, and with whose wife, Ms. Jean Adukwe Mensah, has a close familial relationship. Mrs. Mensah was thus at all material times in the conduct of her responsibilities biased by prejudice in favor of the second respondent and against the petitioner. My lords, we pray that this part of paragraph 26 be expunged as scandalous, prejudicial, and not based on the pleadings. These are very serious material allegations of fact, and they were not pleaded.
Yes.
Now the next part we take objection to relates to paragraph 28, which the portion reads, the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondent seeking to justify after the event Mrs. Jean Adukwe Mensah's 9 December 2020 purported declaration, and that undermines the whole attempt at correction of what was indisputably an error and in error-driven declaration, and shows, and my Lord, that's a critical passage, shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast in the presidential election.
So does your objection start from the secrecy or starts from simply being cooked?
It starts from shows, but you can only understand the shows if you relate to it to what comes before. But the specific objection relates to the showing that the figures were simply being cooked. My lords, we say that this portion of paragraph 28 is extremely prejudicial. No facts have been pleaded to that effect and ought to be struck out accordingly. My Lord, paragraph 30 of the witness statement. My Lord strangely seeks to suggest that the first respondent, because of his bias in favor of the second respondent, somehow.
Could you tell us what you're objecting to? The
whole of the whole of it. Yes, the whole of paragraph 30. My Lord, it seeks to suggest that the new regulations were organized by the first respondent with the object of ensuring that the process of collation and aggregation of votes were introduced without any good reason. My Lord is talking about a piece of legislation. My Lord, it is the witness may not speak to the legal validity of a piece of...
Mr. Kutampo, so is it your objection that it's not based on pleadings, or that it's unduly prejudices, or it's scandalous? You've told
My Lord,
us
it's
three
not
grounds.
based on the pleadings, nor is it, and furthermore, it is unduly scandalous. And my Lord, our next objection. No, I don't want to go there. Our next objection, my Lords, relate to paragraph 32. My Lords, this was not pleaded by the respondents, the petitioner, and my Lord, it relates to 275 summary sheets results. My Lord, nowhere in the petition has there been any reference to any 275 summary sheets. And the petitioner had all the opportunity to do so if he intended to rely on this evidence. In the trial. He failed to do so and is seeking, through his witness statement, to improperly introduce it through the back door. Should be, and we pray, therefore, that it be struck out. My Lords, indeed, if your Lordships take a look at the petitioner's amended petition, even exhibits were attached to the petition when they should not have been. And so they had that flawed tradition, but they didn't. And now, when they asked to write their witness statement, they introduced this huge piece of evidence which they hadn't pleaded. We ask that it be struck out as not based on the pleadings. And consequently, paragraph 33, which is a consequence of paragraph 32, should also, in similar fashion, be struck out. Yeah. I hear you. My Lords, as we've indicated, it is well established that a party's pleadings are fundamental in determining the case he or she intends to make during trial. A party's pleadings also notify the other side of the case that he will meet in court. My Lords, the significance of pleadings have been set out very clearly in the case of Hammond and Odoi. 1982-83, 2 Ghana Law Report 215 at 1215 at 1235 to 1236. My Lords, I know that this statement of the law is very well known to your Lordships, so I will not detain you with reading it. My Lords, I wish further to refer your lordships to the case of Adejumo versus Abegunde and another, reported in 1965 Ghana Law Reports 499, 1965, my lords, Ghana Law Report 499. Which holds that in holding one, well, this is the Supreme Court holding one to the effect, quote, although evidence is inadmissible to prove material facts which have not been pleaded, is bound to take it into consideration. My lords, we are making this objection so as not to fall into that trap. And my lords, we wish, in addition, to refer to the evidence decree. Where's the evidence decree? Evidence Act now, my lords. Evidence Act. Section 51, my lords, which reads as follows: for purposes of this decree, relevant evidence means evidence including evidence relevant to the credibility of a witness or hearsay declarant, which makes the existence or non-existence of any fact that is of consequence to the determination of the action more or less probable than it would be without it. And sub 2 reads, all relevant evidence is admissible except otherwise provided by any enactment. And sub 3 states, no evidence is admissible except relevant evidence. And my lords,
I'm not clear what lessons you want us to draw from
my lord, this. I'll shortly demonstrate if I'm permitted. Section 52B states the court in its discretion may exclude evidence, relevant evidence, if the probative value of the evidence is substantially outweighed by the risk that the admission of the evidence will create substantial danger of unfair prejudice or substantial danger of confusing the issues. Now, my lords, the relevance of this piece of these provisions of the Evidence Act is that they confirm the position that any evidence that will be led must be based on the pleadings and from nowhere surprises the other party and where they do cause, where they provide a danger of substantial or unfair prejudice, may be disallowed by the court. And that is why we believe it is relevant. My Lord, it is for these reasons my Lord, with all due respect, my attention has been drawn to paragraph 37 also. Yes, the last offending paragraph, where the witness states, I quote, "This conduct of certain officials of first respondent in padding the votes of second respondents is in fact indicative of a well-hatched and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of the first respondent to have second respondent unconstitutionally and unlawfully installed as president." My lords, this paragraph is extremely scandalous, and what makes it worse is that apart from the so-called 4,000 plus padding that they allege, and they have not provided any further evidence or made any further plea factoring numbers, or yes, there's nothing in their petition to that effect. My lords, I think it is significant that whilst the petitioner has been making these really scandalous allegations, he has not provided one shred of evidence of his own tabulation of votes. Nothing throughout the petition that to show how totally unacceptable paragraph 37 is, and it ought to be struck out.
Mr. Kutampa,
yes,
let me chip in. You see, the pleading is different from evidence.
Yes.
Pleadings can be struck out on the basis that it's scandalous. Yes. But this is evidence.
And my lord, if it cannot be struck out, it should not be admitted.
No, if a pleading is scandalous,
yes,
yes, it is a basis for striking out.
Very well.
Yes, but the evidence is quite different from a pleading, except that the evidence takes its roots from the pleading.
Yes, my lord, and our case is that these pieces of evidence are not based on the pleadings.
Yeah, so no, but if you yes, you must know the basis of
my lord, they are not based on the pleadings, and they should not be admissible. Being scandalous. My lord, we pray accordingly.
As to what is wrong with paragraph 6 and 7? Paragraph 6 and 7. Yes, what is wrong with that? This is a fact.
Look at it carefully.
Yes.
Yeah, what is wrong with that?
My lord, our view is that those two paragraphs are not matters for his evidence in chief.
They are not matters of...
For
For evidence in chief?
Yes.
No, so assuming we are doing oral trial and the witness is in the box, can't counsel ask him whether in the course of this trial, can he be asked?
My Lord, in the first place, we want to make the point that the witness is a witness. It's not a look at the witness statement. He doesn't indicate that he has a power of attorney. A simple witness of the petitioner.
To find out. When you led him, he said he was
one of why we are here is that we are dealing with the validity of the election of the candidate. And when I look at the evidence, the 36 and 37, the witness just stated numbers, applications, 375 summary sheets, 30,000 and 30 million, 218, and left it at that. How would that affect your case? When there's the validity of election of a candidate. So you have to limit everything, your submissions and your cross-examination, to the validity of the election of the candidate and not a general trial in the High Court. So you're complaining about 32, 33. How would that affect your case, the validity of the election of the candidate? Has the witness made any assertion that because of that, votes and other things and whatnot? So you look at it, if there's nothing, let the trial proceed. Otherwise, we'll be going through this banter and we'll spend the whole time raising objections and this and that. So let's focus on why we are here.
My Lord, that is precisely what I'm trying to do. My point, my Lord, is that the petitioner in his petition has never said anything about summary sheets. Indeed, the petitioner in his petition, in our view, has not challenged the validity of the election. It has simply picked on some errors in the announcements and the tabulation of the results. He has not provided...
And in these two paragraphs, 32 yes. and 33, yes. the witness is also not saying anything about the validity of the election.
Yes.
So why not keep quiet over it? That's what Lord, I've been telling my students in advocacy lectures.
Yes, my Lord, we will not keep quiet over it because it could be prejudicial. It may cast an unnecessary cloud over the elections. It is not being pleaded, and my lords, I believe that they cannot lead evidence that is contrary to their pleadings.
Thank you.
But I want to know whether Mr. Minuvo has something to say about the witness statement. Yes, Justin.
Yes, my Lord. My Lord, I have nothing more to add to what Mr. Akotwampa has said. Thank you. I associate myself with his submissions. My Lord, quite a lot of objections have been raised.
more than 10, I believe. If it were a trial in which oral testimony was being given, in evidence in chief, there would be a series of objections at different points, and then one could take it up. And the practical difficulty I'm talking about is that as he was raising the objections, we were busy trying to deal with it. What I was going to say, my lords, is that as we proceed with the responses, we may need to come back to your lordships for the statement that you have recorded in respect of the objections, so that the answers will be appropriate in terms of what your record shows. That's what I meant by the practical solution to ensuring that we are addressing all the objections. But we're ready to respond to each of the objections, and guided by your record of the objection.
It appears the first objection, I hope you recorded the basis for the objection.
As I said, we're trying hard to record it. But
No. I know that it's very difficult to get the very paragraph. Yes, I'm talking of the grounds for the objections, which were one that it was not based on the pleadings.
The two grounds that he said at the beginning. Yes,
thank you. Yes, the first one was in respect of paragraph 21. Paragraph 21. Then the second, we went back to paragraph 6 and 7.
Yes.
Yes. Then he went to paragraph 25. Paragraph 26.
25, portion.
The portion, not the whole.
From
the latter part of paragraph 25.
Yeah,
yes. Yes. Then he went to paragraph 26. Then went to paragraph 28. Paragraph 30. Paragraph 32. Paragraph 33. Paragraph 37. Yes. Then I think that is all.
That's all.
That is all. Please, yes. Can I go over?
I have the paragraphs, but as I go on, the particular ground that he gave for each paragraph, I may ask. For
no problem. No problem.
Yes, I have the paragraphs. All right. No. Yeah. Now, my lord, the first paragraph, and my lords, I start off with the fairly elementary statement of the law that pleadings are not meant to be evidence. And my lords, Rule 7 of Order 11 makes clear that subject to this rule and Rules 10 to 12, every pleading shall contain only a statement for a claim or defense, but not the evidence by which those facts are to be proved. And this, my lords, that's fairly, and if we take the various objections, paragraph 21 is that, and paragraph 21 follows paragraph 20. So if I may first refer to paragraph 20. In this unsigned press release, first respondent introduced new figures for the total valid votes cast in the presidential election held on 7th December 2020. A copy of the said press release is attached and marked as Exhibit B and was available on first respondent's website, www.ec.gov.gh, as of 11:45 GMT on 29. So even as late as just before the petition was filed, we were pointing out that that document was available. And paragraph 21 is making reference to the fact that following that press release, the results being published by first respondents on this website became moving targets. Well, that's evidence in respect of what happened to the numbers that were provided for in paragraph that were mentioned, that were alluded to in paragraph 20, and becoming moving targets, subsequently deleted the changing figures from the website. That is material evidence that undermines the figures that were in that press release, because there were figures in the press release, as we indicate, an unsigned press release that's, again, very clear, and subsequently those were themselves being changed. I cannot see how this is immaterial. And my lords, particularly in a situation where the witness statement of the first respondent, that press release and the numbers in the declaration. My lords, I cannot with the greatest respect see how evidence about changing figures is not material in these proceedings.
Mr. Speaker, that is not the point. He said it says that this paragraph 21 has not been pleaded. It doesn't take its source from your pleadings. So perhaps if you look at your paragraph 28 and 29 of the petition,
yes,
you may be able to respond to it. The ground is that it has not been pleaded.
Let me just...
Yes, on the pleadings.
Yeah.
If you look at your paragraph 28 and 29, yes, so look, so that you can help it.
My lords, indeed, in our paragraphs 28 and 29 and 30 of the pleadings, we state on 10th December 2020, an unsigned press release of first respondent claimed that its chairperson, Mrs. Jean Adukwe-Mensah, had inadvertently, in quotation marks, used the figure of so-and-so. And then we continue in 29. In this purported corrective press release, first respondent introduced two completely new figures for the total votes cast in the presidential election. Thus, there was no correction properly so-called. Since to be valid, a correction of a prior mistake must correctly name the mistake to be corrected. In this case, the mistake to be corrected was itself mistakenly stated. The numbers so-and-so are completely different. And then paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of transparency. That is pleaded. And then it goes on in paragraph, it goes on paragraph 31. I'm sorry.
So go to paragraphs 6 and 7.
Now, in paragraph 6 and 7, your orders in terms of the filing of the witness statements, we actually drew attention to this issue of the request to admit facts, how it's precisely to indicate to your lordships the parameters within which his evidence is are being placed, because those parameters are...
We are worried because, you see, Mr. Esiedu Ketia is not the petitioner. He's not a party, strictly speaking. He's just a witness, as you rightly pointed out. So let's look at it in that.
Yes, but my lords, he is a witness of the petitioner. Yes. And as a witness of the petitioner,
he can swear everything in the proceedings.
He can, yes, he can, my lords,
as a witness,
he can swear which he is aware of. I mean, those processes are, in fact, a matter of public record, literally.
Because, you see, we don't want, sir, we don't want a situation where, under cross-examination, a question is put to him. Do you know anything about notice to admit?
My Lord,
no, the situation can arise because you see here, he is or not.
My Lord, he
is or not.
Oath, and I'm sure that he will be able to take care of himself on oath.
No, we want to avoid a situation where maybe.
No, my Lord, with respect,
we just want to streamline the way things should be done.
Yes, and my Lord, respectfully. Well, my Lord, frankly, there is no difference in terms of these particular paragraphs, because the petitioner is not himself the lawyer filing those processes. The petitioner, yes, but the petitioner gives the instruction and a witness of the petition processes, because he's a witness of the petitioner, and as a witness of the petitioner, he familiarizes himself with processes that are filed. And in fact, more importantly, as a witness, and the point of those paragraphs is what I have to put in my witness statement. That is part of the point. And my Lord, and that is why, in fact, before he went into the witness box, I did draw your Lordship's attention respectfully to the fact that we wanted guidance on whether we needed leave subsequently after those issues are resolved with the search that we're making. And your Lordship said he should go into the witness box. So my Lord, I have no doubt that the witness is able to address those issues in terms of his knowledge of the facts of what has been done on behalf of the petitioner. I have no doubt about that. In respect of Article 23 of the Constitution, which provides that, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal, unquote. In fact, the ever-changing figures put out in the unsigned press release and what was posted on the website of the first respondent in respect of the declaration of the presidential election betrayed the determination on the part of Mrs. Jean Adukwe-Mensah as returning officer for the presidential election and certain official of first respondent to have second respondent installed as president of Ghana on 7th January 2021 by hook or by crook. Now, my lords, in the pleadings, in paragraph 33, my lords, in fact, if I may start actually from paragraph 20 of the pleadings. I may even start from 19, because in 19 is the statement, first respondent and his chairperson, Mrs. Jean Adukwe-Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Paragraph 20, in declaring second respondent as the winner of the 2020 presidential elections on 9 December 2020, the chairperson of first respondent, Mrs. Gina Dukwemensah, acted in flagrant violation of the 1992 Constitution.
Mr. Chikata,
Mr.
Chikata,
yes.
Could you hurry to where it is your pleading that she intended to install the second respondent by hook or crook, or where this evidence takes its roots from?
In paragraph 21, we say that first respondent, she was required to act fairly, reasonably, candidly, and not arbitrarily or capriciously. And then we go on in paragraph 24. We go on to point out that she was required not to be biased either by resentment, prejudice, or personal dislike, and also requires them to exercise discretionary power in accordance with due process of law. So we are pleading the fact that these were requirements placed on her, and evidence to show that she did not comply with those requirements is certainly available on the basis of those pleadings. And as I indicated, in relation to
law, and you then go on to draw the conclusion or to conjecture that she was determined to declare the second respondent as president by hook or crook.
My Lord, that
is just
my Lord, that's not a conjecture. That's not a conjecture. If they want further and better particulars of it, of course they're entitled to ask for further, but it is not a conjecture. And we are saying that these are matters that are demonstrated in the various pieces of evidence, especially relating to ever-changing numbers on the website that will obviously be before you. And in fact, most of these are not denied. It's not denied that there were every other figure that we've seen in these proceedings. Now, my Lord, we are saying that all this is evidence of a predetermined agenda. That is, you know, my Lords, in proving facts, in proving...
This is really what I wanted you to show, that the statement or the pleading that there was a predetermined agenda to end in a particular way. That's what I'm trying to find from your pleading.
That is a necessary implication from the ever-changing figures that were supplied right up until the point of the answer. And my Lord, that is a matter that circumstantial evidence is obviously permissible in proving facts. So
hold on, say. So your response is that this allegation of hook or crook is actually intended to lead us to a conclusion that is made out of inference. Is that what you're saying?
It's based out of the circumstantial evidence, the compelling circumstantial evidence.
It's an inference. It's an inference that you are making. And you know, inferences are alien.
Yes.
In evidence. You can be an address, but not evidence.
Yes, my lords, I said we are giving circumstantial evidence on the basis of which conclusions.
So what you are describing as circumstantial evidence is an inference. You are making an inference. And evidence, we don't do inferences.
My lord,
you can address on it.
My lord, these are not inferences. We are saying there was a predetermined agenda, and we are saying that that predetermined agenda is evident from the ever-changing circumstances and from the refusal to act in accordance with the responsibilities to be fair and candid. We say in paragraph 22 that She refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. We say in paragraph 23 that prior to her making the said purported declaration, Mrs. Jean Adukwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of these concerns. My lord, if evidence cannot be given in relation to all these matters and how they lead to the inevitable conclusion of a predetermined agenda, then respectfully, I don't know what else we're supposed to do in terms of providing evidence. We go on. My lords, I'm not finished. We go on in paragraph 30. In paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. My lord, I mean, one should, with respect, take cognizance of the various elements of our paragraphs in the pleadings. The fact that there's no explanation, there's a total lack of transparency, these are all things that have been pleaded. And if evidence is being led in terms of the predetermined agenda and the determination by hook or by crook to arrive at a certain result, I cannot see how that evidence can be regarded as objectionable in any way. They can cross-examine on that evidence. They can seek to discredit him and say that he has no basis and whatever. But we cannot say that that evidence is not admissible. Now, my lords, I believe the next paragraph was the Gazette notice is required to be based on the declaration actually made by Mrs. Jean Adukwe-Mensah as the chairperson of the first respondent. I'm sorry, that's our pleading. 26 of the witness statement. Yes. The 26 of the witness statement is where the chairperson of first respondent and first respondent are also not required under Article 296 of the Constitution any discretion. Respondent who appointed her in August 2018 and with whose wife Mrs. Jean Adukwe-Mensah has a close familial relationship. Mrs. Mensah was thus absent. Now, my lords, we have the requirement of compliance with Article 296B. And in turn, in their answer, paragraph 39, paragraph 40 of their answer, in further denial of the petitioner's claims, first defendant says that it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias against anyone. So there's a denial of our allegation. There's a denial of that. And therefore, a witness that is speaking, she actually goes on in paragraph, the answer goes on in paragraph 41 to talk about, in a bid to enhance transparency and public participation, it took certain steps. So, my lord, clearly the answer of the first respondent shows her recognition that the issue of her bias is part of what has been pleaded. And she is asserting in paragraph 40 that she did a first respondent, well, in fact, respectfully, that paragraph just says the first respondent. It doesn't speak specifically about her. So we should take the words as they are. The first respondent says it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election, with fairness to every candidate and without malice, ill will, or bias. So clearly, there is an issue that is before this court of whether there is bias to anyone or in favor of anyone or not. There is an issue.
So, Mr. Secretary, where in your pleadings did you plead that there's bias because the first respondent, in a way, is related to the wife of the second respondent? Where?
My lords, we plead the 296B, bias by either by resentment.
We don't plead law. We don't. 296 is.
My lord, we plead the operation of that law are being contested because we have to state that the Constitution has this requirement in order to point out that that requirement has not.
But then they went further, as you rightly pointed out in, I think, was it paragraph 40? Yeah, 40. Yes. And then they pleaded in answer that they complied with the law and that they were not biased, and they went through with the due process as required by law.
So
yes, but then if you go further and we are concerned with the last paragraph of paragraph 26. We are not comfortable with it.
That is their problem.
That is their problem.
The paragraph starting from the chairperson of first responder, Mrs. Jane Adukwe Mensah, allowed herself to be biased by her prejudice in favor of the second responder, who appointed her in August 2018.
Yeah, that is
and with whose wife, Mrs. Jane Adukwe Mensah, has a close familiar relationship. Mrs. Mensah was thus, at all material terms in the conduct of her responsibility, biased by prejudice in favor of the second respondent and against the petitioner. They are saying that this has not been pleaded. This fact, this evidence, is not based on the pleadings.
We are saying respectfully that what is contained in the witness statement is evidence of the pleading of non-compliance with Article 296B, because that is part of our case.
No, but you must plead before. I mean, the thing does not even appear in your pleadings. So how can it turn to become evidence? The thing does not appear in your pleading. We have not read anything like this from your pleadings, from the petition.
Don't you think the close familiar relationship should be a material fact that based on Order 11, Rule 7, you should include in your pleadings?
My lords, I am not of the view that by itself is a material fact that should be reflected. And my lord, let me be clear. Bias could be related to a number of different factors. A close familiar relationship is a potential element. And if, in spite of the close familiar relationship, there is action taken that reflects due process, transparency, and everything, then in that situation, the close familial relationship would not affect the conduct of the proceeding. So it is really a matter of evidence whether in the context, in the circumstances that we're dealing with here, whether we have a situation in which that familial relationship has actually affected the conduct of the responsibility. That is a matter of evidence.
How does she respond to this?
She responds your evidence. To that.
This was not in your pleadings. This was not in your pleadings. Are you not taking her by surprise?
Well, we don't believe that this takes her by surprise, because this, I'm sure, is legally. There are facts that are very well known to her. In fact, there are facts that are.
But we don't know. We're sitting here, we don't know. Until we read this, we didn't know.
Okay.
Okay.
My lords, we are saying that in respect of paragraph 26, I'm concluding my response on paragraph 26. Am I allowed to do that? We're saying that in response to paragraph 26, these allegations of bias are sufficiently referenced in our pleadings in relation to the operation of Article 296B. And we're saying that the denial that is contained in paragraph 40, that denial indicates that the petitioner is not taking the first respondent by surprise in respect of the allegations of bias that are in the witness statement. Now, that's in paragraph 28. I understand that the objection is to a portion of that paragraph, and if your lordships could clarify which portion. Yes, the secrecy and lack of transparency regarding the figures thrown up by one or more officials or first respondents seeking to justify after the event, Mrs. Gina Adequate-Mensah's 9th December 2020 purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration and shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast. My lords, I have referred already to our pleadings in respect of transparency, and I have also referred to our pleadings in respect of these changing figures. And if I may go over that again for the purposes of this response. Of votes cast, votes obtained, paragraph 8 of the amended petition. 95 of the total valid votes that she herself distinctly stated to have been 13,434,574 was a manifest error, as votes cast for second respondent would amount to 50.098 and not the 51.595% erroneously declared. And then in paragraph 12, which I referred to before, we indicate that if the total number of votes standing to the names of each of the presidential candidates is summed up, this would yield a total number of valid votes cast of 113,121,111, a figure that is completely missing from the purported declaration by Mrs. Gina Adequate-Mensah on 9th December 2020 and the purported rectification on 10th December. So we have already intimated these initial changes. And then we proceed, as I indicated previously, we proceed to make reference to the fact that this is in paragraph 22
which I referred to before. Mrs. Jean Adukwe-Mensah predetermined prior to the 7 December 2020 presidential and parliamentary elections that she would announce the results within 24 hours after the close of polls. Consequently, she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. Prior to her making the said purported declaration, Mrs. Jean Adukwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of those concerns, and the letter is attached. And then we also further indicate the lack of transparency that was involved in the purported corrective press release. And this we do in paragraph 30, in seeking to justify the new figures put forward in the press release. Various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. There's a direct reference to the lack of transparency in that paragraph. And we go on further in paragraph 31 to say that the so-called rectification of the errors in the purported declaration was itself egregiously wrong, and we go on to provide. So, my lords, in paragraph 33, if Mrs. Jean Adukwe-Mensah, as returning officer of the presidential election, had determined in good faith that her declaration on 9th December 2020 was in error, her constitutional duty to be fair and candid, and my lord, that explains why we had reference to the constitutional duty in the pleadings. That her constitutional duty was to be fair and candid required her, among other things, to acknowledge the error, set aside her erroneous declaration, and proceed on the path to correcting her error, respecting the rights of candidates to participate in the processes towards the making of such a declaration. So we indicate what transparency required. We didn't just say lack of transparency at large. And we go on in paragraph 34 to say that the unsigned press release of first respondent has no value in the determination of the validity of the declaration that Mrs. Jean Adukwe-Mensah made on 9th December 2020, especially as the issue of the release was not undertaken transparently and in accordance with due process of law and established practice, including the participation of affected candidates through their respective agents. So we have pleaded everything that we need as a foundation for pointing out that what was done secretly, in the sense that it was done, without reference to any of these candidates, completely by themselves, and not in accordance with the legal requirements for the participation of agents of the candidates. I mean, all these paragraphs that I've adverted to are specific in reference to lack of transparency, lack of contact, consultation with anybody. And my lords, I mean, I cannot see how the witnesses' indication that the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondents seeking to justify after the event Mrs. Jean Adukwe-Mensah's 9th December purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual votes cast in the presidential election for the various elections, for the various candidates. So, my lord, the point we are making is that there has been sufficient basis laid in the pleadings for there to be evidence that shows that figures were just being cooked, because the figures are coming out of nowhere and without reference to anything that is transparently communicated to anybody. My Lord, with the greatest respect, I find it very difficult to see how any objective observer of the ever-changing figures that have been put forward can fail to see that we are not justified in talking about figures being cooked. And my Lord, figures being cooked is simply an indication that the figures are, just being thrown up, unrelated to valid votes being cast, counted, and collated, which is what it should be. So, my Lord, respectfully, we would submit that there is a basis in our pleadings about lack of transparency, lack of due process, in respect of paragraph 30, and if your lordships could again perhaps read out what the ground, the specific ground is, so that...
Are you asking for help with paragraph 30?
Yes.
30, the whole of the paragraph.
Yeah.
On the basis that...
Yeah.
On the basis that the witness cannot speak to the legal validity of the legislation referred to, that is at the CI
127.
Okay, my lords, this again is not a pleading of law at all. This pleading states in the new regulations promulgated, and it's not an issue about the validity of the constitutional instrument. That is not the issue. In the new regulations, this is just a factual statement about how the new regulations operated. In the new regulations promulgated by first respondent, CI 127, it now interposed between the strong room and the constituency collation centers, without any good reason, another layer of collation at its regional offices with regional summary sheets. That is a fact. It did that as a result of the constitutional instrument. This led to results being sent from regional collation centers which were at variance with the results collated at constituency collation centers as a result of figures being altered by officials of first respondent. Exhibit C provides sample details of wrong aggregation of valid votes on the face of the summary sheets of some 11 constituencies. The exhibit shows that the sum total of votes, of valid votes obtained by all candidates varies from the figure recorded on the face of the summary sheets as the total valid votes from each of these constituencies. Now, my lords, the statement there is quite clear about the interposition of the regional collation centers as a source of errors. And an exhibit, Exhibit C, is also provided in the petition with the sample details. Now, my lords, it needs to be clear. It needs to be clear that in this petition, unlike perhaps in the 2012-2013 2013 petition. The petitioner did not come to court saying that, and now 4 million votes of voters who have voted. And now then, because in some cases pink sheets didn't have presiding officer signature, or there were duplicate serial numbers. That, in the nature of this petition, the petitioner is saying that a certain declaration was made on the 9th of December. It was publicly made, we all heard it, and the petitioner is saying that when you look at figures in that declaration itself, those figures do not amount to compliance with a constitutional provision duly. That's what the now, in this paragraph 30, what the petitioner is seeking to do is precisely to provide, as it is said, a sample of wrong aggregation, and the petitioner is attributing that to the interposition of the regional collation center. So that is the import of that paragraph, and that import is related to the lack of transparency pleadings that we clearly have.
Mr. Chikata,
yes.
Your pleading indicates that that interposition comes from the new regulation, from the law. Isn't that your pleading?
The new regulation is, I didn't hear the last bit of
the testimony of the witness is that the interposition,
the new regulation
interposed, yes.
Yes.
And that's the source of the trouble. That's the source of the complaint.
Yes, in its operation, the way it operated, the way this new regulation was operated in practice.
And the objection is that it seems to suggest that the new regulation of first respondent was about ensuring that the process of collation and aggregation of votes were introduced without good reason. And yet that was introduced through a law. It was a law that provided that framework. And yes, that is a complaint.
It was subsidiary legislation made by the electorate, the first respondent, and the witness statement is indicating that the operation of that, it was a matter of law, leads to wrong results. That's what we're saying. I mean, you could operate the creation of regional centers in a transparent way, which does not inviting just needed a link. One of the ways in which that lack of transparency was demonstrated in the actual conduct of the first respondent. That is what the witness statement is seeking to do as a matter of evidence.
But Mr. Chikat, there is nothing in the petition about this, let me call them collation issues. There's nothing in the petition that the collation process resulted in changed figures or figures changing.
We have pleaded the fact that numbers were being changed by the first respondent without any transparency.
No, now, this is such a big issue that this polling station to this constituency to this regional collation center, these figures changed. There's nothing about this in the petition.
My lords, the petitioner is not the returning officer for the presidential election.
Oh, but he's the one challenging
the petitioner. May I answer you? The petitioner is challenging, firstly on the basis that you made a declaration in which you put forward certain numbers. On the face of your declaration, those numbers do not warrant your exercising your constitutional responsibility the way you did. That is the basic point of the petition. My lords, if I may finish my answer, because I believe it's important for the answer in its fullness to be heard. That the petitioner makes clear that her challenge is based on the fact that the person who is a returning officer, that person has purportedly made a certain declaration of someone as having won the election. And yet the figures that she has put in as the basis of her declaration, those figures do not warrant her declaration. That is the heart of this matter. Now, my lords, at the heart of that petition is this issue about the numbers that were acted upon by the first respondent. First respondent puts forward an answer in which effectively first respondent says, I am actually admitting that there were errors. That's what first respondent is saying. First respondent is saying, I'm admitting there were errors, but one, they were inadvertent. And they were corrected by a press release on the 10th of December 2020. We point out that the so-called correction itself contained mistaken figures. We point that out very clearly. And we further point out that those figures kept changing right up until the point where we have in the witness
my lords,
statement.
with respect, counsel has been repeating the same things for the past 15 or 20 minutes. It's the same thing he's been repeating.
My lords, I don't know whether that's meant to throw me off the course of my argument, but I think with respect, this is intolerable with respect, because I was in the middle of a sentence actually, and you know, it is not appropriate, you know, to make this kind of interjection.
Yeah, please, when you want to raise an objection, it has to be timeously raised. Yeah, so that, yes, you don't disrupt.
My lord, I thought I was actually raising it timeously.
My lord, I believe I was in the process of explaining that at the heart of the petitioner's petition before this court is a challenge to the constitutional consequence arising from those figures. And we're saying that we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you are supposed to be speaking to paragraph 30, which is about the collation. And the question from my brother on my right was that there is nothing in your pleadings about the collation process.
My lords, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, you know, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. So the witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through, these 4 stages, and so she is in effect explaining herself in terms of her conduct, and we are saying that on that basis the witness is entitled, because my lord, if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead him and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? My lord, that's perfectly legitimate if I were leading him in the normal course.
Counsel, in fact, with the greatest respect, my problem is this. In the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127, the law that regulated election.
And the petitioner does not seek to raise a
statement. The witness is trying to raise issue with CI 127.
No, my lord, the petitioner is raising an issue over the interposed that regional coalition center. My lord,
you see, that were the provisions in CI 120. That was the regulations that regulated or governed the elections in the CON 27. There have been changes now, strong room to constituency coalition. That's what CI 127 said the election should be conducted.
And EI 127. It's a position without good reason. If the petitioner has, as a result, had problems in the collation, which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outlined in their answer. My lords, I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from paragraph 5.
No, Mr. Chiketa, we don't want you to read that one. We are familiar with that.
So, my lords, if I could, in oral testimony, leading him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent, which says they went in accordance with this and this and this and that? My lord, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of votes and so on. There are pleadings made in relation to that with exhibits provided. And my lords, I do want to insist, and your lordships can correct me, if he were being led in the witness box in oral evidence, would I not be able to put the case of the first respondent to him? I could.
You could, but the way you have framed the evidence in paragraph 30, whom are you blaming? Mr. Chiketa, look at paragraph 30 carefully. Whom are you blaming?
Whom am I blaming?
Yes, this evidence.
Blaming?
Yeah, blame. B-L-A-M-E.
But
blame.
My lord,
is it Parliament or the first respondent or the structure that was
my lord, frankly, Parliament has nothing to do with this.
Yeah, because what he did...
Parliament has nothing to do with it, because this is subsidiary legislation.
But it was laid before Parliament.
Yes, but I mean,
it was laid before Parliament for 21 days.
My lords, anyway, my lords, I believe that is really not the essence of, because it
totally is. It's the essence.
So is Parliament responsible for all subsidiary legislation laid before them?
That's money.
Please.
The testimony, as far as I understand it, you are blaming CI 127 on her, because you are saying that out of 127, CI 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
No, we're saying that the implementation of the law is what occasioned the problems. And that this interposition without good reason was the opportunity for that really error-ridden implementation to take place. That is what we're saying.
But the problem is with the implementation of the law. Then in essence, the first defendant, the first respondent, did violate the law. Well, you've not indicated anywhere.
You don't have to violate a law in order to implement it in a way that occasions...
If you don't implement it correctly, as provided in the law, then you have violated it.
Well, my lords, we are saying that there was a lack of due process. There was a lack of due process in the implementation. The lack of due process is certainly an aspect of the implementation of the law. It does not require us to challenge the law or to say that the law itself is the problem. We're saying that in the implementation of a law or of a statute, a piece of subsidiary legislation that she introduced without good reason, we're saying that that was a part of the problem. And we've given a sample of why that occasioned the problems. In paragraph 32, indeed, aggregating the votes, yes, my lords, aggregating the total valid votes as shown by the 275 summary sheet released by the first respondent on his website, the resultant figure is actually 13,200, which is different from the 9. I mean, my lords, how can there be an objection to that passage of evidence? That is a passage of evidence in which reference is being made to the website of the first respondent in order to address figures that she has sought, or figures that her first respondent has put forward as a correction of other figures that she read, which we all heard. She's put forward those figures. And here, and then subsequent to that, there is published on the website, 275 constituencies. And we do our arithmetic and we say that those figures actually result in this, not in the figure of the proposed correction. How could that possibly not be, you know, I mean, a piece of material evidence from a witness in this election petition, aggregating the total figures. And my lords, this comes directly following paragraph 31 after the 7th December 2020 presidential election. Petitioners, paragraph 31 of the witness statement, petitioners representatives in the strong room discovered that there were errors as a result of which they did not certify the summary of the results from some of the regions. They also noticed anomalies with some of the collation sheets that may have been inputted into the results. Based on the observations, the NDC calls a letter and so on. And then indeed, and it follows by talking about what what the first respondent put on the website, which is in contradiction to what she purported to be the correct figures. I mean, my lords, and what is more, those figures are different from what...
They are not making any case against paragraph 31. Yeah.
Yes, but paragraph 32.
It's 32.
Paragraph 32.
They are not quarreling with
paragraph
31.
32 is stating quite clearly that the figures that were published by the first respondent on their website, when you put them together, and this again is a matter relevant to the different figures that were being offered by way of correction on the 10th and later. So I think this is a very material, every piece of evidence, especially, my lords, when it is acknowledged that the witness can have put to him the case of the first respondent. The case of the first respondent is that an inadvertent error was made and it was corrected. And the correction itself was subsequently corrected. And we're saying that when you take what is on their own website, this is effectively in the nature of an admission by them that they were wrong even in their purported correction. This is a clearly material piece of evidence, and in paragraph 33, which is the last, I think the last but one, again, this is a statement of that point, that the aggregated figure from the total valid votes as shown by the 275 summary sheets released by first respondent on his website. This figure is also different from the corrected figure of 10th December in the unsigned press release. So paragraph 32 makes reference to the figures on the website, and then paragraph 33 says that that was also different from the corrected figures. And my lords, with the greatest respect, the issue that is at stake in this petition is the conduct of the first respondent as the returning officer of the presidential election. And that conduct...
Mr. Chikata, which relief relates to the conduct? If we look, which relief? For settlement. You're seeking declaration.
The issue that we've put down, the relief that we have put down is a relief. We have put down a number of reliefs. Now, relief A is that the chairperson was in breach of Article 63(2). Relief B, a declaration based on the data in the declaration made, the data contained in the declaration made by Mrs. Gina Adukwe-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7th December. No candidate satisfied the requirement of Article 63. The third relief is a declaration that the purported declaration made on 9th December of the results of the presidential election by Mrs. Gina Adukwe-Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7th December is unconstitutional, null and void, and of no effect whatsoever. Now, I mean, we have set out in the preceding pleadings the basis of our claim of unconstitutionality. We've set them out, including the failures in respect of Article 23 and the failures in respect of Article 296. We've set them out. And we're saying that a declaration that is unconstitutional should be made. And in paragraphs 32 to 33 of the witness statement, we are responding as we're entitled to we're responding to the case that the first respondent is putting forward, in which she puts forward certain numbers and we are relating those numbers to what she herself had, or what the first respondent had put on their website. And with the greatest respect, that is clearly a relevant matter. Now, my lords, I have to say that, I mean, these attempts to, take out of our witness statement extremely material matters that relate to the case that is being presented by the first respondent, I mean, are really matters that we consider, really very, very seriously, because we cannot see how anyone can objectively claim that these changing figures that we have been talking about as part of the lack of transparency and so on cannot be accepted as part of the witness's witness. Paragraph 37, this conduct of certain officials, and maybe, again, my lords, paragraph 37 cannot be read in isolation of the previous paragraph, because when it says this conduct, the meaning of this conduct cannot be read without going back to 36. In 36, because 36 says, Exhibit F is a spreadsheet covering sample details from 26 constituencies showing vote padding by certain officials of first respondent in favor of second respondent. When the votes second respondent obtained in all polling stations are shown on their respective pink sheets in these 26 constituencies are aggregated, the resultant figure differs from the figure that was declared by first respondent for second respondent as captured on the summary sheets of the respective constituencies. They show that more votes were added to those of second respondent than he had in fact obtained. So this is a conduct that is then referred to at the beginning of 37. This conduct of certain officials of first respondent in padding the votes of first respondent is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers, with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of first respondent to have second respondent unconstitutionally and unlawfully installed as president of Ghana. So this again is evidence that concludes paragraph 36, and paragraph 36 is not being objected to, and it concludes paragraph 36 and indicates that this conduct that is referred to is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers. And my lords, whether indeed numbers were being manufactured or not is obviously a question of fact. It's an issue that is to be resolved by the evidence of the parties and by the determination of which evidence is worthy of acceptance as truthful evidence. And therefore we submit that none of these passages of evidence can be considered as passages that cannot be legitimately within the witness statement of our witness.
With the leave of your lordships. we wish to refer to Order 11 to reply. Yes. Yeah. May I have the lead of the court to reply? My lords, I wish to refer to Order 11, Rule 12.1 of CI 47, which reads, and I quote, subject to Sub-Rule 2, every pleading shall contain the necessary particulars of any claim, defense, or other matter pleaded, including, but without prejudice to the generality of the foregoing words. A. Particulars of any misrepresentation, fraud, breach of trust, willful default, or undue influence on which the party pleading relies. And B. Where a party pleading alleges any condition of the mind of any person, whether of any disorder or disability of mind, or malice, or any malice, fraudulent intention, or other condition of the mind, and except knowledge of particulars of fact on which the party relies. My Lord,
Mr. Akutuampa, what you've just read is for the practice and procedure in the High Courts.
Yes.
Yes, and that's not what is before us is not pleadings properly so called. Yes. This is an election petition.
Yes.
And it's regulated by rules and other things. So we have made it clear that we are not applying the High Court Civil Procedure rules in this case. We are applying the Evidence Act to regulate the taking and admissibility of evidence in this case. So allow us to regulate the procedure, because this is an election petition, because it appears it's something new. So the lawyers keep on referring us to the High Court Civil Procedure rules and other things. But this is a peculiar jurisdiction which we are exercising.
No. My Lord, my understanding is that these rules may provide guidance to the court, and it is part of our legal practice, but where a party alleges matters relating to a state of mind, like predetermined mind and prejudice and so on, he must give particulars in his petition. The petitioner never gave the particulars relating to the alleged predetermined intention, the bias, and so on. None of these matters, particulars, have been pleaded. And we would urge, based on that and all the other things we have submitted to this Honorable Court, that the pleadings, the evidence, the paragraphs in the evidence, many of which are actually material facts which ought to have been pleaded, should not be admitted. We pray accordingly.
Respectfully seek your permission, because a point of law, a new point of law has been raised. Because as the law is that well, very well.
All rise.
my friend over there. Hey, Azoto. Hey, Azoto.
What's up?
Charlie, how?
Charlie,
did you go for the test we talked about the other time?
Oh, yeah, man, I do them simple.
Oh, you do them?
Oh, I do them.
Hey, Azoto!
I do them.
Charlie, this is great. Oh, guys, pardon. This is my friend Azoto, another bold, wise person who is just taking the HIV test.
Wow!
That's a wise decision.
Thanks, man. Azoto, we a Bemba Kasan.